We've had a lot of legal wins since even just 3 years ago. What do these legal wins show? Do you want to start?
Well, I can say very shortly what I think they show, which is that judges do largely, by and large, understand the law and apply it properly and understand how to conduct the relevant balancing exercises and how to I mean, almost all of the cases have been in employment tribunals, so I'm going to bang the drum for the very fine jurisdiction of the employment tribunal, where we deal with very, very complex law, much more complex than most people think, and the Equality Act is particularly complex, especially when it butts up against the Human Rights Act, and those are the two pieces of legislation which come into play here and require a great deal of balancing. And we have seen in case after case that the judges have undertaken that process very effectively. There have been one or two situations where, where there's been a bit of a slip, but they've ended up with us getting appellate decisions which have been certainly very useful for my own practice, I must say. So that's to be applauded. I've seen quite a lot on Twitter from activists to the effect that these cases have been lost, essentially. Only, you know, one or two small points, technical wins, and so on, which I've been slightly flabbergasted by. But I think there's a lack of understanding that nobody, almost nobody, ever wins every single point that they fight. These have been, it's been a stunning line of case law. I've been a barrister for 24 years now, and I've not seen a line of case law like it in that time, and I feel extremely privileged to be working in this field, actually.
I just want to abuse my position as chair and say one or two judges are incredibly well written in their judgments, and all I'm going to say is paragraph 22.
So after my case and my appeal, where it was found that gender critical beliefs are worthy of respect in a democratic society.
Hey.
I think there have been 6 other cases since, and it's interesting, even in my appeal judgment and then the judgment in my case after, the judge were quite wary of saying anything nice about me, basically. You know, they decided, you know, not quite a Nazi, worthy of respect, you know, you can have these beliefs, but, you know, they're quite offensive. And then over the course of the 6 cases since then, you can see the judiciary kind of warming up, and you can see them looking at the complaints on the other side. I think in my case, it was the first time they'd seen this, and they really thought, well, these people who are complaining, you know, they've got good jobs, they're serious people, they seem very upset, you know, they're in the,
have done something.
Yeah, they're in the LGBT community or they're allies, I mean, and they've been trained, you know, and they'd had the Equal Treatment Bench book, and, you know, these are good people, good, smart people. She must have done something wrong. We can't really find out what it is, but we're not going to say anything nice about her. And then over the course of the judgments, you can see it sort of dawning on them that something is wrong in these institutions. And is paragraph 22 the one that says, you know, I had all these academics in front of me.
They lacked a certain robust...
Yes, yes. You know, and you can see this dawning on them in the case of Rachel Mead, the social worker, in the case of Denise Farmy, who worked for the Arts Council, you know, whose colleagues created this petition against her. Rachel Mead, it was one colleague witch hunting her that started it all, and in Ros Adams' case, I mean, by that point you can kind of see the judges going, what is going on in these organisations? So I think that's quite interesting, and they all obviously read each judgment. So I hope it gets easier to show when people get to tribunal, or hopefully, you know, so that they don't get to tribunal, that these complaints are unreasonable. And I think one really important thing from the Denise Farmy case was it was the fact of having the complaints and having the complaints, unreasonable complaints being investigated was harassment. And in the Rachel Mead case, calling her beliefs transphobic and bigoted was harassment. You know, if you take any group of people with a protected characteristic, you know, if you say, you know, the Irish are lazy, sorry, just, you know, a random example.
I'm putting the case in tomorrow.
Oh, yeah. But, you know, any example of a group of people and you say, these people are a bad thing, that's harassment. And all over workplaces, they're saying, you know, zero tolerance of transphobia, asterisk, transphobia is basically defined as us. That's harassment. So, so there are going to be lots more cases, but hopefully they're going to get easier, hopefully they're going to get cheaper, and hopefully employers are going to get smarter so that they don't end up in that situation.
I don't think we can promise cheaper.
Well, quicker. Quicker, because
Maybe
the judge,
quicker.
We
you know, the
need
judge
to be able to have Akua being able to buy her T-shirts,
Yeah.
right?
Exactly.
I don't mean quicker by hour. I'm cheaper by hour. I just mean quicker.
Fewer hours.
As in-
No, but I do
Yeah.
agree it is preposterously expensive to pursue tribunal cases, and we have seen one or two, I think, where people have tried to do it on their own and have been less successful, and it is an area of law. I mean, I would never advise somebody to go to tribunal on their own, but particularly not in this, where the judges are less at home in it and where the law is complicated.
I mean, it's taken a long time to get to here. So when the Race Discrimination Act came in, there was, you know, basically there were a set of cases that came to the equivalent of employment tribunal. I think they were called industrial tribunal at the time. And, you know, the first ones, employers would turn up confidently and say, oh, it's not me that's the biggest, you know, it's my customers. I can't have a black person on the front of house. Like, no one's going to come in here if I, you know, and they're like, no, sorry, you've lost. Oh, well, they won't work with him, you know, that sort of thing. So it sort of, roughly speaking, took about a decade before employers actually got the memo that no, you can't say it's because the staff are bigots, it's because the customers are bigots. Just no, you have to treat people fairly. So that's kind of a discouraging, it's going to take a decade. But I'm sorry to say I think it'll take longer. Because if you think about the history of racism, it's not like there was some wonderful non-racist bit before we all suddenly decided, bizarrely, that we were going to pay attention to skin colour. Which is what has happened here. Like 30 years ago, we weren't doing this. I mean, we were discriminating against women big time, yes, but we weren't pretending that sex wasn't real and discriminating against people who said that sex was real. So we taught everybody to do that, and now they think they're doing the right thing, and we've got a whole load more workplace training than we had 30 years ago. I mean, nearly everybody has been through some workplace training, and the stuff that we see is appalling, absolutely ridiculous. Like, it gives examples of transphobia that are, you know, saying, sorry, this is the ladies, to a man, you know, that sort of thing. So everybody's been trained in all of this stuff, and we have to try and rip it out. And the thing that I found most surprising and disturbing after this run, this extraordinary run of wins, all wins on our side in a row, is how little difference it's made to practice. I mean, Riddle Wadwa is still running the Edinburgh Rape Crisis Centre. I know, and I mean, you know, Social Work England, I don't know if they're going to do the things that they were told that they should do in their employment tribunal. I mean, Joe's old university, Open University, said that it's going to do a review, and it picked a legal advisor for that review who spends her time saying things about TERFs online. They've got rid of her now, but I mean, it feels like the levers are broken to get the institutional response that we need from these wins. So what can we do in that situation? I mean, I think the obvious one is just that it's actually very expensive. I mean, our estimate was that the OU spent £1 million.
Easily.
Yeah, against Joe. Like £1 million to defend a bunch of bullies trying to destroy a woman's life. You know, that's enough money, you know, that's the sort of money, sooner or later, £1 million here, £1 million there, it adds up, you know. So you can start saying that to people. If you want to be spending this sort of money again and again, you can if you like, or you can actually start to think about this properly. But it's not going to be as easy as I thought it would be a year or two ago. I thought employers would go, oh, we've got this wrong.
Yeah, well, I mean, I think the reason why they haven't changed as quickly, perhaps, as they might in the face of such an extraordinary line of case law is to do with something that one of you two raised a moment ago, which is the training and the external bodies that come into workplaces and other institutions to deliver training, which is just simply erroneous. I mean, it's so deeply rooted. And, you know, the outsourcing of that sort of training, which purports not to be legal advice, but is obviously taken as legal advice because it's about legal things and it's training about how to comply with the law. So one wonders how it can be not legal advice. It's just very deep-rooted, and people don't know which way to turn.
It raises, for me, it raises a really big question, though, and it's one that, although I won, and I'm very happy about that, it's one that I still struggle with, both intellectually, politically, and just on a personal level, and that's how we turn judgments into justice. Because I think that's, you know, the driver for most people, and Maya, you can correct me if I'm wrong with you, but the driver for most of us who go to law is to attain some sort of justice, and yet judgments aren't quite translating as quickly as they'd like. So I'm going to leave you out of this, and just, sorry, I don't mean that dismissively.
No, it's fine. I was just going to say the judgment is supposed to be the justice. Yeah. That's how we think of it. But I mean, I understand you want something further than that.
Yeah, well, it's, you know, it struck me as the most amazing thing in an employment tribunal that the judgment, yes, it's the justice, but the employer can carry on doing exactly the same thing. They don't actually have to do, I mean, they might be facing legal cases, but they don't have to change. So just, yeah, judgments to justice.
Well, I think it was you that told me when I was in my case, don't expect justice.
Yeah, it was.
Don't expect, you know, kind of anything, you know, emotionally what you need from it. And I thought that was good advice. But I think, you know, it was such a weird thing to be having to bring a case based on the belief that men are men and women are women. It just such a weird thing. And my case and most of the other cases that came after were all about people wanting to talk about this and being disciplined or harassed for wanting to talk about it in general terms. You know, Jo wanted to talk about prisons, but she wasn't a prison officer. I wanted to talk about, you know, toilets and changing rooms and all kinds of things. But actually in my office, it wasn't a huge office. We had one, you know, single toilet like you have at home. But the cases, the most recent ones, particularly Ros Adams and Edinburgh Rape Crisis Centre, was about somebody whose job, where sex mattered in her job, and in order for her to, you know, be able to keep her clients safe and treat them with respect, she had to be able to say that sex is real. And the judge in that case, they, like all of these judgments, they start with, I'm not saying anything about trans rights and women's rights, you know, but you are. And the judge in the Ros Adams case said that, you know, I'm not taking a position between the position that sex is real and immutable and the other position, which is mad. No, they didn't say that. And I'm not taking a position on that. But then if you read the judgment, really they did take a position on that because they recognised that what Ros was doing was sensible in her job. And now the cases that are coming now, the cases of the nurses in Darlington and the nurse in Fife, are about applying the same ideas in a, you know, how does this work when you're talking about an employer's changing rooms, an employer's toilets, you know, employers who are employing people and safeguarding. And in those cases, I think they're not going to be able to carry on. You know, they're going to have to resolve it one way or another so that they actually change their policies. Not, you know, it's not just about, oh, of course you have the right to say these things on Twitter, which is good, or in the democratic process, which is good, but that employers are doing a job, and that job often involves being clear and reality-based about sex. And I think that is where we'll get to with more of those kinds of cases.
And I think, sorry, just to interject, but I think, you know, hopefully the judges will have regard to the Supreme Court authority that they do actually have to grasp the nettle in these situations when it's necessary to do so. It's been, I think, a slightly disappointing aspect of the case law, the number of judges who've said, oh, I'm not taking position. And in fact, the full-page disclaimer at the front of Maya's Employment Appeal Tribunal judgment, which so many people are treating as if it's the judgment itself, which it isn't at all. But this sort of insistence that they're not taking a position is just really unhelpful, extra fluff. And there is authority to the effect that they really do need to come down on a side, pick a side in circumstances where it's necessary for the judgment to be effective.
I think that, you know, there isn't a symmetry here. I know that sometimes people say, you know, why did this case have to be brought under belief discrimination? It's not a belief that there are two sexes, it's reality. And, you know, one answer to that is you use the tools that are available. What do you want people to not be able to talk about this at work, or do you want them to be able to talk about it at work so we can fix it? But more than that, I would say that the belief, and if you read what Maya said her belief was, there's two parts to it, a bit like saying that you believe in man-made climate change is a very serious problem. Like, there's a bit that we never have to say with that, which is, you know, there are solids, liquids and gases, and there are certain elements, and the methane is a greenhouse gas. We all take those as facts. And then on top of that, there's the belief that man-made climate change is a big issue. So you could say, well, you know, there are two sexes, that's actually not a belief. And that matters. That's the belief bit. There are people who think it doesn't matter, or that we shouldn't be allowed to talk about it, or that women are just all whinging, and, you know, if we want to be able to work, then we have to accept having men get their cocks out in our showers or whatever, you know. Like, there are people who have all sorts of mad beliefs on top of the facts. I won.
I was just going to say
We had a
that.
bet. We each had a word that we had to say while we were on the stage.
That was not one of them. That was not it.
That wasn't it, though. That was not your word.
And cock was not the
No.
word.
It was penis, so I think I win.
I come to that. Anyway,
Vagina.
yeah, so what helps in all these situations is, on our side, is clarity. What helps them is obfuscation. And things can only, like, if you clarify things, you can't reconfuse them. Like, they've managed to do an awful lot of confusing, but if we managed, for example, to clarify the Equality Act so that sex really means sex, like, people say, well, Labour will come in, or some future government will, or what if, you know, the EHRC loses its way again, or something like that. And, you know, well, what? We go back to saying, maybe it is sex or maybe it isn't. That's not the way laws work. If it's really clear, it's very hard to then confuse it again. So sooner or later we get to the point, whether that's because of a legal change, guidance, Supreme Court judgment, you know, a series of case laws, where we really know the answer to the question, this woman needs to have an internal vaginal exam. And she has said she is only willing to have it from a woman. This man has a piece of paper saying he's a woman. Does he have the right to walk in and stick his fingers in her vagina? We have to have an answer to that. And if the answer is, he has a GRC, you bigot, then we have to follow that chain of thought all the way to wherever we have to say women have human rights too. And this is Article 3 violation, by the way. And if, as I hope, they say, well, you know what, we didn't actually think of that when we wrote this law. Of course he doesn't. Then we're off to the races that way. So clarification is what we want, or clarity.